Okay, Chair, you're good to go.
Colleagues, we're now ready to proceed to the executive session calendar. We'll consider these items in the order in which they appear on your calendar. The first item is executive session consent calendar. My next question is probably irrelevant because there is only one item on this consent calendar.
Right.
I was going to ask if anybody wants to pull this item off, but as I say, that's irrelevant. So any questions on the consent calendar for the executive session, colleagues? Hearing and seeing none, the administrator will call the roll. Pardon me?
She has to make the motion.
Oh, pardon me. Vice Chair, since you're here, please make a motion.
Thank you, Chair. I move the commission approve the executive session consent calendar as presented.
Thank you. You've heard the motion. Ready for the vote. Administrator will call the roll, please, on the consent calendar exec session.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez is abstaining. Commissioner Mettler.
Aye.
Commissioner Jancy.
Aye.
Commissioner Helt.
Aye.
Commissioner Macaulay.
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0 with one abstention.
Thank you. Okay, colleagues, the item number 2 on our agenda deals with Danielle Bethel from Marion County. She is not appearing. Remember, our process here on these preliminary reviews is a 5-step process. The first being the investigator's report, questions. Respondent can then appear before us if he or she chooses to do so. Question for that person, then our vote. That said, the investigator in this case is Investigator Fenstermaker. Please proceed. Item number 2.
Thank you, Chair Fiscom. Commissioners, I'm Casey Fenstermaker. Agenda item number 2, case number 25-574 ECF, is a preliminary review report regarding Danielle Bethel. The complaint in this matter was filed alleging that Marion County Commissioner Danielle Bethel used her position to try to help her daughter get out of a traffic ticket. A review of the dash cam footage indicates that when Danielle Bethel's daughter was pulled over for a traffic citation, she called her mother regarding her expired insurance card. Commissioner Bethel is heard on speakerphone telling the deputy sheriff that she could send a copy of the current insurance card by phone. When the deputy sheriff explains how to handle the charge regarding the expired insurance card, Commissioner Bethel advises that her daughter can't go to court in Marion County because she's a commissioner and asks the deputy to be thoughtful before sending her. Commissioner Bethel then reached out to Judge Kidd regarding this matter, providing details about the citation and the traffic stop. Marion County Council provided commission staff with relevant evidence and information, but also provided a written statement in support of Danielle Bethel and indicating that her statements do not violate any ethics laws and are constitutionally protected speech. The statement also states that the deputy sheriff just got the wrong impression regarding her statements. And the statement argues that the emails with Judge Kidd do not rise to an ethics violation. Oregon government ethics law prohibits a public official from using or attempting to use their office to obtain or attempt to obtain a financial gain or avoid a financial detriment for their relatives. A child is considered a relative under Oregon government ethics law. It appears that Commissioner Bethel may have used her office to attempt to avoid the financial detriment of a traffic ticket for her relative. It also appears that Commissioner Bethel may have used her office to have county council submit personal argument in an attempt to avoid the financial detriment of hiring an attorney in this matter. Therefore, the recommendation is to move this case to investigation as there is a substantial objective basis to believe Commissioner Danielle Bethel may have violated Oregon government ethics law.
Investigator, colleagues, the time is now for questions for our investigator. I'm looking for hands raised. If somebody has a question, just for the record, remember that this Commissioner Thompson is declaring a conflict, potential, not an actual conflict, but it's going to be abstaining from our process in this matter. Any questions, colleagues, for our investigator? Any suggestions about how to move on this matter?
have a question maybe
Vice Chair, please.
for our legal counsel. This is the first time in our investigative report where it seems that we're making some sort of allegation that a response by county council on behalf of a commissioner would lead to a improper use of office. And it seems like we've received responses from county council on behalf of commissioners quite often. And it seems that we even have received responses from county council on behalf of public officials in other instances, even in this meeting book. So I'm wondering why this instance in particular raises that potential violation as opposed to other instances. If that could be, if there could be some response on that, that would be helpful for me.
Okay, I'll let staff speak to the factual piece, but
Okay.
As far as use of office, so it is fine for county council, city attorney, any others to respond on behalf of the organization itself. So if the county is taking a particular position as to what occurred factually, that would be okay. Where it looks more like a use of office is the county employees cannot use their county attorney as their personal attorney. And so when an allegation, whether it be ethics or public meetings, is alleged, those are personal to when it comes to OGC, those are personal to the individual public official. And so they can no longer use the attorney for a response for themselves. So to the extent that any response argued a position on behalf of the person, it starts to look as if they used their position in order to use the attorney to respond on their behalf.
Right. And it seems like that happens quite often. And it seems like it happens quite often that county council appears and makes some sort of representation that the person did not engage in some sort of conflict of interest, or it seems like this is the first time I'm seeing where we are potentially saying that that's a violation of the use of office. Maybe I'm missing something, but it seems quite often that county council files some sort of response, and maybe they clarify, oh, this is just on behalf of the county, but they still say there's no violation. Am I incorrect on that?
So the ones that I remember,
Yeah.
are public meetings related usually. So the county council or the city attorney is explaining what occurred at a meeting, or explaining, if it was an executive session, explaining that they engaged with counsel during an executive session or something of that nature. I'm not aware of any, but
Yeah.
as far as
Yeah.
Executive, please.
Yes, so historically, quite a long time ago, more than 8 years ago, there was a case, and it was, I think it was the original complaint was a violation of executive session laws. And in the course of the investigation of the violation, the respondents all basically made the decision to authorize the city's attorney to represent them before OVAC, which led to a separate case, an ethics violation against them for using their office to avoid a financial detriment. Based on that, OVAC's advice to people when things would come up is to sort of rely on those decisions and say, look, if you are using your public body attorney as your representative, if there is a policy or agreement or insurance policy or something that authorizes it, that's okay. But for that, it could potentially violate use of office. About maybe 3 or 4 years ago, we issued a staff advisory opinion, commitment opinion, that basically laid out in light of knowing the public meetings law complaints would be increasing. We issued that to explain to public body attorneys sort of how that determination gets made, so that if they want to make a statement as representing the city or the public body, that would be fine. But absent some policy or ordinance saying they can represent these people personally, that advocating as a representative of the individual could lead to an additional ethics violation.
Vice Chair, please
Can I
follow.
follow? So it would not be a violation if it's part of their compensation package. And there's some sort of policy that says that as part of their compensation package, they can be represented personally by their public body attorney.
Correct. It
Okay.
could be part of, we've seen entities that have an insurance policy saying that the attorney can represent them. There would have to be some either policy, ordinance, bylaw, something that says this could take place.
Thank you. That's very helpful.
Vice Chair, more?
No,
Anything else? Thank you.
that was very helpful.
Colleagues, there's still time for ask any questions that you have of anybody here, including and especially our investigator after that report. Looking around, hearing and seeing no hands, the time has now come for us to decide how to proceed on this matter. Looking for any comments anybody chooses to make. You ready for your motion, Vice Chair?
I am. I move the commission find there is a substantial objective basis for believing that Danielle Bethel may have violated ORS 244-040 subsection 1, and that the commission should investigate accordingly.
For the motion, colleagues, any questions about it? Hearing and seeing none, the administrator will call the roll, please. Item 2 on the executive session calendar.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Thompson is abstaining, Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez is abstaining, Commissioner Halt,
Aye.
Commissioner McCauley,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0 with 2 abstentions.
Colleagues, thank you. We can move directly into item 3. Again, our records show that this is involving Danielle Bethel again, and she is not appearing today. So we'll move directly without a technology pause to our investigator, who again is Investigator Fenstermaker. Item 3, please.
Thank you, Chair Fiscom, Commissioners. Again, Casey Fenstermaker for the record. Agenda item number 3, case number 25-618 ECF. The preliminary review report regarding Danielle Bethel. Complaint in this matter was filed alleging that Marion County Commissioner Danielle Bethel failed to declare a conflict of interest and voted on a contract that would benefit a business that her son is employed by. Commissioner Bethel's son is employed by Slating Constructors Incorporated. At the September 3rd, 2025 Marion County Commission meeting, Commissioner Bethel failed to declare a conflict of interest before discussion of contract amendments with Sladen. Failed to declare a conflict of interest before discussion of the contract amendments with Sladen and before they were considered. She also voted to approve both contract amendments. Marion County Council submitted a statement indicating that he provided her with legal advice regarding the type of conflict she was required to declare. A public official is faced with an actual conflict of interest when they take an action or make a decision or recommendation in their capacity as a public official, which would be to the private financial benefit of a business that a relative is associated with. Again, the child is considered a relative. When faced with an actual conflict of interest, an elected public official is required to publicly declare the nature of the conflict of interest and abstain from discussing or voting on the matter. In this case, the contract amendments would be to the financial benefit of Sladen Constructors, Inc., a business with which Commissioner Bethel's son is associated. The recommendation is to move this case to investigation as there is a substantial objective basis to believe Commissioner Danielle Bethel may have violated Oregon government ethics law.
Investigator, any questions based on the report that you've both read and just heard, colleagues? Hearing and seeing none, Vice Chair, you ready for a motion?
I am Chair, thank you. I hereby move that the commission find that there is a substantial objective basis for believing that Danielle Bethel may have violated ORS 244-120 subsection 2, and that the commission should investigate accordingly.
Colleagues, you've heard the motion. Item number 3 on our agenda. Any questions about the comments on the motion? Hearing and seeing none, the administrator will call the roll. Item 3, executive session, please.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez is abstaining, Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Halt,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson is abstaining, Chair Biscom.
Hi.
Motion passed 6-0 with 2 abstentions.
Thank you, colleagues. We're going to just pause for a minute while our staff alerts Rebecca Sawyer, who's in the building, to the fact that we're ready to open a matter involving her. She has asked if it would be okay, permissible if her husband were to attend with her, and I have okayed that. So in a few moments, they will come into the room and we'll wait for their arrival before we proceed. This is item number 4 on your executive session agenda, Rebecca Sawyer from the School Board of Days Creek School District. Welcome. Please pull up a chair and make yourself at home. Ready to go? Colleagues, we're now going to open the matter on item 4 on your agenda involving Rebecca Sawyer from Douglas County School District 15. Welcome to the Ethics Commission today, Rebecca Sawyer, and your husband's name is? Charlie Sawyer. Welcome here, both of you. This matter involves Miss Sawyer, but we're pleased that you're here, Mr. Sawyer, so we'll allow both of you to be in the room. Our process here is 5-fold. We'll hear a report from our investigator, may have questions for the investigator. We'll allow you to make some comments to us in a few moments. Then we may have questions for you. And the 5th step is to move toward a decision. So welcome to Salem. Our first step will be to hear a report from our investigator, Casey Fenstermaker. Please proceed.
Thank you, Chair Fiscom, Commissioners. I'm Casey Fenstermaker for the record. The next case is a preliminary review report regarding Rebecca Sawyer, agenda item number 4, case number 25-591 ELG. The complaint in this matter was filed alleging Rebecca Sawyer accepted a position as an educational assistant with the Days Creek Charter School while also serving on the district school board. The complaint also alleged that Rebecca Sawyer's husband was awarded a contract for a water management position. The complaint alleges that there is no indication that either the position or the contract were competitively bid. Based on a review of the available evidence, it does not appear that Rebecca Sawyer was required to declare a conflict of interest while sitting on the district school board, but she was not yet employed by the Days Creek Charter School as an educational assistant. It also does not appear that Rebecca Sawyer was required to declare a conflict of interest during the educational assistant application and hiring process. However, it does appear that Rebecca Sawyer was met with an actual conflict of interest when the school board considered and voted to approve her husband's contract during a school board meeting. It appears she only declared a potential conflict of interest without describing the nature of that conflict, and it appears she only did so after discussion of the matter had started. When met with an actual conflict of interest, a public official is required to declare their conflict of interest prior to any discussion or vote on the matter, and then abstain from voting on the matter. It does not appear that Rebecca Sawyer used her office to either obtain her position or to obtain her husband's water management position. But again, there is, we recommend moving this case to investigation as there's a substantial objective basis to believe that Rebecca Sawyer violated Oregon government ethics law by failing to properly declare a conflict of interest at the appropriate time and by failing to describe the nature of that conflict.
Thank you, investigator. Any questions for the investigator? I have one, but I'll yield to colleagues for the moment. Any questions? Mr. Thompson, please.
what would you be looking for if you moved this forward? Probably the same as chairs, but
I do believe there was a recommendation of something that we would have taken a look at, but I would need to pull it up
The
here.
investigator is developing her answer to that question, which is also mine. What else would we do? Do we need to do?
Yeah, there's no, again, there's no belief that there was a prohibited use of office.
Right.
So I believe we have the information that we would need
Right.
to move forward. I don't believe there would be any substantive investigation to.
Thank you. Commissioner, follow up?
nope. Thank you, Mr. Chair.
Any other questions? Commissioner Halt, please. By the way, for our visitors today, welcome here again, as I said, but just so you know, there are 3 or 4 commissioners online as well as 3 in the room here today. So we hope you'll tolerate that as we have remote possibilities that would have enabled you to appear remotely had you chosen to do so as well as here. So thank you for being here. Commissioner Halt, please. Commissioner Halt and Ben,
Thank you,
so
Chair Fiscom. My question is around working for a charter school. Is it allowed for a school board member to work in the district that it oversees? Thank you.
colleagues, investigator, do you have an answer to that question?
Well, I was going to say that is not relevant in this particular case simply because if I understand and remember the facts correctly, the time period on the board ended and 3 days later was when she began her employment with the charter school. So the 2 positions did not overlap.
Good dog. Thank you.
Thank you.
Okay, hearing and seeing no other questions, the time is now for our respondents to make any comments you choose to make to us. Do me a favor and introduce yourself for the record, make any comments you choose to make, and we'd ask you to be on point and as brief as possible. Thank you for being here. Please proceed
Okay,
in any order you choose.
okay. Thank you. My name is Rebecca Sawyer. And I appreciate you having me here today to talk about this case. I'll make it brief because I know that the report is quite thorough. But I just wanted to make a couple of points. First one is I did not use my board position in any way to influence any hiring. As has been shown in the report, I resigned from my position before beginning my employment with the school district. Excuse me. And secondly, there was a question in the report about the water position and the stipend. And that was unclear apparently from the job application. There's a $2,400 stipend, and that is annual. So it's a $200 per month position. Just wanted to clarify that for the record. And then thirdly, I did state my abstention in the vote for the water position. That is on record that I did abstain. I did not participate in the discussion. And it does state in the public meeting minutes that my conflict of interest was such that my husband was being considered for the position. Excuse me. But I did not do that in the correct order. And I didn't realize that at the time. And my apologies. I appreciate your correction on this. And if I were to be in public office again, I would certainly be careful with that. But I didn't vote or participate in discussion. So my apologies.
Thank you for your comments. Colleagues, any questions for Ms. Sawyer based on what she said? Hearing and seeing none at the moment, I would just say that before we decide how to proceed in this matter, for the record, I would say that this is an example of another case where it would be advantageous for us as a commission, in my judgment, to have the ability to issue a letter of education to a respondent in light of what we now know and in light of the respondent's comments that she has now understands the law that we enforce better than she did before. We do not have that freedom under Oregon law at the current moment. Just for the record, I wanted to say that. Colleagues, any comments before we decide how to proceed?
Chair, if I could be recognized.
Please, Vice Chair,
Um,
hang on a minute. Any other hands? The Commissioner Halt, hang on a minute. Vice Chair, please.
I'm inclined to move to dismiss or to vote to dismiss this case. I think we have discretion to do so. I think, even though she didn't do so in the correct order, I think she took steps to announce a conflict. She abstained from the vote. And I think, in my opinion, this is one where we could use our discretion to dismiss. I think education has happened, and that's where I'm leaning.
Thank you, Vice Chair. Commissioner Held, please.
Yeah, I just want to concur with what the vice chair has stated. I think it's overly punitive to worry about order when I think the ethical requirements were met. Thank you.
Hey, Commissioner, any other comments, colleagues, as we head toward a decision here? Hearing and seeing none for the moment, I'll turn to the Vice Chair for a motion.
To Susan? Yeah. Okay. Okay. So, for executive session agenda item 4, I move the commission dismiss the complaint against Rebecca Sawyer.
Heard the motion, colleagues. Any questions about it? Hearing and seeing none, the administrator will call the roll. Item 4, executive session agenda today. Please proceed.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Halt,
Hi.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Thank you, colleagues. Thanks to the Sawyers for being here today and for traveling north to see us. We appreciate it. The result of this has been, as you've just seen and heard, dismissal. So thank you for your participation with us and your patience with our agenda today, and drive safe heading south.
Thank you very much. Appreciate you. Sam.
Thank you. Okay, we'll pause now for just a moment, colleagues, to have the exit and entrances related to the next item, which is number 5 on your agenda, involving Sherry Wilkins, who is not appearing. So we can sort of forge ahead, right, Executive?
Daniel, are any of them appearing?
They are not.
Okay, so yeah, 5, 6, and 7 are somewhat interrelated.
Right, and then my records show that
Separated together.
Separate, just because the circumstances are very different.
this is item 5, similar to in some certain respects, but not exactly the same as 6 or 7. We'll proceed one by one. The investigator in all cases is Daniel Pacheco. Mr. Pacheco, on item 5, please proceed.
Thank you, Chair Fiscom and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 5 in your meeting books is a preliminary review report for Sherry Wilkins, member of the North Gila County Health District. In this case, Ms. Wilkins' spouse, Brian Wilkins, is an employee of the North Gila Medic Department, which is overseen by the Health District. The complaint in this matter concerns 2 2025 District Board meetings, a July 15th regular meeting and a July 31st special meeting, each in conjunction with an executive session. At these meetings, the board considered the compensation of Medic Department staff when discussing employee settlement agreements and an ongoing policy that would curb overtime pay. In this case, Ms. Wilkins was elected near the end of the July 15th meeting, and it does not appear that she engaged in actions or decisions requiring a conflict of interest disclosure. However, based on the information gathered, it appears that she was met with the statutory conflict of interest at the July 31st meeting. As Ms. Wilkins' husband is a Medic Department employee, she would be met with a conflict of interest anytime she took actions or made decisions that would or could financially impact her relative. In this case, it appears that Ms. Wilkins failed to declare her actual conflict of interest prior to the board convening an executive session to discuss the policy and settlement agreements, and again when the board voted to approve them in open session. By failing to do so, it appears that Ms. Wilkins violated 20 sub 2 on 4 separate occasions at the July 31st meeting. Based on the information gathered, there is a substantial objective basis to believe that Sherry Wilkins violated ORS 244.120 sub 2. The recommendation in your books is to move this case to investigation. Thank you.
Thank you, Investigator Pacheco. Any questions for our investigator based on what you've read and heard? My question, maybe if this is embedded in your document, I apologize for not remembering it. If we were to proceed pending a vote we haven't taken yet, what would you be looking at next?
Thank you for the question, Commissioner Fiscom. So there wouldn't be any more further information to review. If this case moves to investigation, most likely we would offer a stipulated final order and run it through the penalty matrix to see what we can offer.
And it might be a letter conceivably without predicting that specifically.
Yes.
Probably inappropriate to ask that question right now, pending your review. Comments, colleagues, questions? How would you like to proceed? Question? Vice Chair, the motion, please, on item number 5.
Thank you, Chair. I hereby move that the commission find that there is a substantial objective basis for believing that Sherry Wilkins may have violated ORS 244-1202 and that the commission should investigate accordingly.
You've heard the motion on item number 4, colleagues. Questions on it? Hearing and seeing none, the administrator will call the roll. Item 4, please. 5, pardon me. Item 5, I apologize. We're on item 5 now. Please proceed.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Halt,
Aye.
Commissioner McCully,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Okay, colleagues, we will move on. Investigator Pacheco will now be reporting on item 6 involving Mr. Grant Wilkins. Please proceed.
Thank you, Chair Fiscom and Commissioners. It's Investigator Daniel Pacheco for the record. Then item 6 in your meeting books is preliminary report for Grant Wilkins, member of the North Gillian County Health District. In this case, Mr. Wilkins' relatives, his spouse, Tiffany Wilkins, and his brother, Brian Wilkins, are medic department employees. The complaint in this matter concerns the July 15th and July 31st meetings. At these meetings, the board discussed employee settlement agreements and an ongoing policy that would curb overtime pay. While Mr. Wilkins' spouse had declined the money in their settlement agreement, they were entitled to $2,200 while his brother receives about $1,700. As any action, decision, or recommendation made by Mr. Wilkins in his official capacity regarding the district policy or settlement agreements, which would or could financially impact his relatives, either positive or negative, would give rise to a conflict of interest requiring his disclosure. In this case, it appears that Mr. Wilkins failed to declare the nature of his actual conflict of interest during the executive session portion of the July 15th meeting and July 31st meetings when the board discussed the policy and settlement agreements, and again at the July 31st meeting when the board discussed and voted to approve the policy and settlement agreements. By failing to declare the nature of his actual conflict of interest and abstain from discussions or voting on matters that could financially impact his relatives at the 2 July district meetings, it appears Mr. Wilkins violated ORS 244.120 sub 2. Should this case move to investigation, commission staff would seek to determine whether Mr. Wilkins took other actions concerning his relative settlement agreements and whether he properly declared his conflicts of interest. Additionally, it also appears that Mr. Wilkins is one of 3 individuals authorized to sign district payroll checks. Should this case move to investigation, commission staff would seek to clarify whether he signed or approved district payroll checks, which would or could financially impact his relatives, and whether he discloses conflict of interest. Based on the information gathered, there's a substantial objective basis to believe that Grant Wilkins violated ORS 244.120 sub 2. The recommendation in your meeting books is to move this case to investigation. Thank you.
Investigator, and I appreciate the last part of your report, which specified what in the world you would look at next for both me and Mr. Thompson, not to mention all the rest of my colleagues. Any questions, colleagues, for our investigator based on what you've just heard and or read? No one is appearing today from the respondent standpoint, so we're ready to move on this issue. I'm ready. Vice Chair, please.
I hereby move that the commission find that there is a substantial objective basis for believing that Grant Wilkins may have violated ORS 244.120 subsection 2 and that the commission should investigate accordingly.
You've heard the motion. Questions, colleagues? Hearing and seeing none, the administrator will call the roll. Item 6.
Commissioner Jancy,
Aye.
Commissioner Halt,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke, sorry, he's absent, Commissioner Thompson.
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
You colleagues, we will now move ahead to item number 7, involving Mr. Brian Foster, and Investigator Pacheco is still in the hot seat. Please proceed.
Thank you, Chair Fiscom and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 7 in your meeting books is a preliminary review report for Brian Foster, member of the North Gilliam Health District. In this case, Mr. Foster was elected to the board at the July 15th district meeting. Additionally, as a former medic department employee, his name was included in the settlement agreements and with other medic department staff. While Mr. Foster had declined the compensation, he was entitled to $3,007. As any decision or recommendation made by Mr. Foster in his official capacity in the settlement agreements, which would or could financially impact him, either positive or negative, would give rise to a conflict of interest requiring his disclosure. Based on the information gathered, it appears that Mr. Foster failed to declare the nature of his actual conflict of interest when the board discussed and voted to approve the settlement agreements. In this case, at the July 15th executive session, and again at the July 15th meeting when the board discussed and later voted to approve them. By failing to abstain from discussions or voting on matters concerning his own settlement agreement, it appears Mr. Foster violated ORS 244.120 on 3 separate occasions. Based on the information gathered, there's a substantial objective basis to believe that Brian Foster violated ORS 244.120 sub 2, and the recommendation in your books is to move this case to investigation. Thank you.
Investigator, any questions for our investigator colleagues?
I have a
Seeing none, Vice Chair, please.
I have a question. On page 60, it lists out the monetary compensation that each person would receive, and it lists $0 for Brian Foster. Is there somewhere else that it lists that he would receive compensation?
It was just the amount that was calculated by district staff. Sorry, can you repeat your question one more time?
Yeah, I'm just confused because on page 60 of the report, it lists how much compensation each person would receive under the settlement agreement, and it lists $0 for Brian Foster. So I'm just confused as to how he has a conflict of interest if he's receiving $0.
So the way that we had determined that was that because he was still met with a conflict of interest because he was still entitled to that money, and he had made the decision sometime after the fact that he did not want to receive it. So during those discussions, when the board was discussing the settlement agreements, he was still met with a conflict of interest that could either give him a financial benefit or a detriment. Him deciding not to accept the money is after the fact doesn't negate his having to disclose his conflict of interest when that matter was being discussed.
Is the amounts listed on page 60 the amounts accepted or the amounts they're entitled to?
Amounts that they were entitled to.
So he's entitled to $0. I don't understand how I'm sorry. If he's entitled to $0, I don't understand how he could have a financial benefit under the settlement agreement.
I'll let staff address the factual piece, but if it is also a detriment. So if he was entitled to, say, $500,000 and he chose to sign for $0, that would be a detriment that he would still have a conflict for. I don't know the particular fact with respect to him, but that is a potential conflict as well, or an actual conflict as well. And then there's the other question of whether or not the agreement has any, if he accepted no money, whether the agreement exists in law, period. But
And I apologize, Commissioner Payne, I misspoke. So for page 4, where we outline all the district settlement agreements that were voted on, that was just the amounts that were accepted during the meeting. That wasn't actually what was calculated by the district staff that calculated the full amounts. So I misspoke.
Okay, so he was entitled to some amount.
Yes.
This was the amount that was accepted, and so he accepted $0.
Correct.
Okay, thank you.
Even
for
though
that.
entitled to something other than 0. Is that
Yes.
fair? Yeah, thank you.
Thank you.
Other questions? Commissioner Held, please.
Thank you, Chair Fiscom. I don't understand. I'm how he has a conflict of interest because he did not take the money. So he may have intended all along not to take the money. So I would move to dismiss, like I would be leaning towards dismissal of this because I don't think there's a conflict of interest because he didn't benefit, which we've clearly stated.
Any comments on the, in response to our commissioner? Commissioner Thompson, please, and then
I
investigator.
see Commissioner Helt's point very, very clearly. My question, though, revolves around the potential was still there. He may not have had an actual conflict because he didn't take the money, but he still had a potential conflict because the money was offered.
Because he could have taken the money,
Right.
if you want to use those verbs.
Right. So that's kind of where kind of where I'm coming down right now is I understand there was no actual conflict because he didn't take the money, in my opinion, but there was a potential because he could have.
Could.
And I-
Investigator, please.
Thank you. And I want to add one last thing regarding the settlement agreements. Even though Mr. Foster did not accept any money in the agreements, there was language indicating that he waived claims against the board or his receiving or not receiving the compensation. So there was still that financial component. Thank you.
Okay, any follow-up, Mr. Help?
Yeah, I just, I don't understand, he may have intended all along not to take any money at all, so I don't see the conflict. I think we're trying to, say as a potential conflict by what he's thinking and when he's thinking it. And I just disagree. I don't think he has a conflict because he didn't take the money. Thank you.
Thank you. Vice Chair, any comments or are you ready for a motion?
I am ready to make a motion, Chair.
Thank
Thank
you.
you. I hereby move that the commission find that there is a substantial objective basis for believing that Brian Foster may have violated ORS 244.120 subsection 2 and that the commission should investigate accordingly.
Heard the motion, colleagues. Any other comments on the motion before we vote? For the moment, hearing and seeing none, the administrator will call the roll, please, on item number 7.
Commissioner McCauley. Aye. Commissioner Resendez Gutierrez.
Aye.
Commissioner Help.
Nay.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Jancy.
Aye.
Commissioner Mettler.
Aye.
Chair Fisco.
Aye.
Motion passed 7-1.
Your colleagues, I voted aye because I think if there's anything that can be resolved about what the gentleman was thinking and when he was thinking it, that can be resolved in the investigation that we conduct, and an appropriate disposition can be made later by all of you at a later moment. That's why I voted yes. I appreciate your comments, Commissioner Help, and your motion, Vice Chair.
This
We'll now move.
dump stuff on us all day.
The standard line I have written down from. Okay, we'll now move to item number 8, and we will allow our staff to alert us to when we're ready. Mr. Alphonse, if I'm saying his name right, has been in the waiting room, and we will now go through the entrance process online. He's alerting us he wanted to be on Teams today for this matter, item number 8.
So should be good.
Thank you. Mr. Alphonse, can you hear me? We see your picture. You're on mute now for what that's worth, but. Mr. Alphonse, you can take yourself off mute if you would like.
Okay, can you hear me?
Thank you very much. Thank you. For the record, my name is Dave Fiscom. I'm Chair of the Commission. This is the matter. This is the time now set for consideration of the issue involving you. Our process is fivefold. We'll have a report from our investigator, ask questions of our investigator. We'll hear from you, ask questions of you if we have any, and then make a decision. So thank you for joining us online. We appreciate you being here. The investigator is Investigator Sullivan. Please proceed, Mr. Sullivan.
Yes.
Item number 8.
Thank you, Chair Fiscom and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda item number 8. This is a complaint against Tom Alphonse, President of the Board of Directors for the John Bay Water District. The complaint in this case alleges that Tom Alphonse used his position on the board for financial gain by issuing checks to himself, his son Nathan Alphonse, and his business Alphonse Excavating LLC. The information in preliminary review indicates that During the relevant period, Tom Alphonse received 3 checks from the district. Nathan Alphonse received 43 payroll checks, and Alphonse Excavating LLC received 3 checks. The information provided by the district indicates that the payments issued to Nathan Alphonse and Alphonse Excavating were for payroll and services rendered, and the payments issued to Tom Alphonse were reimbursements for funds he loaned to the district to pay for bills they received when there were insufficient funds in the district's bank accounts. It appears that Tom Alphonse may have been met with actual conflicts of interest each time he participated in reviewing and voting to approve the district's financial transactions, which included payments to himself, Alphonse Excavating, and Nathan Alphonse at the board's monthly meetings, and when he signed checks issuing those payments. It does not appear that Tom Alphonse publicly announced his actual conflicts of interest, nor does it appear that he refrained from participating in the matters as a public official. Although it appears that there may have been a significant amount of repairs completed by Alphonse Excavating, for which the district has not been able to pay due to financial difficulties, it also appears that Alphonse Excavating may have been able to acquire and perform this work by using information that was not otherwise available to the public and obtained from Tom Alphonse's position on the board. Thus, it appears that Tom Alphonse may have engaged in a prohibited use of office. The information also indicates that Nathan Alphonse, in his position as operations manager for the district, is supervised by Tom Alphonse along with the other members of the board. It does not appear that the district has adopted policies specifying when Tom Alphonse may directly supervise Nathan Alphonse. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Tom Alphonse may have violated the nepotism, prohibited use of office, and conflict of interest provisions of Oregon government ethics law. The recommendation is to move this case to investigation.
Investigator, any questions based on what you've heard and or read from our Investigator Sullivan colleagues? Now's the time for questions if there are any. For the moment, hearing and seeing none, Mr. Alphonse, if I'm saying your name right, this is your time to make any comment you choose to make to us. Please do so, and thank you for your attendance by remote means. We're happy to have you here. Please proceed, make any comment you choose to make, identify yourself for the record, and we'll listen to what you have to say.
Thank you, Dave. My name is Tom Alphonse. I've been on the John Day Water Board since the mid-90s. I was asked to join. It was and still is not a responsibility I wanted or had time for. At that time, I had just become a self-employed excavating contractor alone. The John Day Water operator, Albert Smith, who is deceased, started using my services after his longtime contractor died. After a few years of contracting services, the locals, unknown to me, voted me president. This compelled me to help. Not by choice. I have a family and a business that required all of my time. I felt this was not a position I was prepared to fulfill, even temporarily. I live in the district 48 years. I've gained accurate understanding of the system layout and construction. For the lack of participation of others, I've been reelected ever since. I still do not want this responsibility. I contracted for the system with Albert until he retired in 2014. My son became certified and also begrudgingly took his position. We had a bookkeeper, Sandy Osterholm. She handled all of John Day's income and expenses. All financials were printed monthly, and each board member, including Richard Elfring, were able to view and access all income and outgoing checks every month. I have never had control of the John Day Water checks. All checks are co-signed with 1 or 2 other board members. I have never written a check to myself or Nathan. In fact, my company is out over $70,000 in services, parts, and repairs that the district has been unable to repay. The district is essentially broke. The John Day buys treated water from the city of Astoria, which the John Day Water at this time owes the city $170,000. It was $225,000. Because of my son and within the district, we have been forced to keep water on for people to maintain water. Richard Elfing has been what seemed to be like on the same page until approximately 18 months ago. Since that time, he became extremely combative. He is opposing all other board members and refuses to participate even in signing the checks. He has been presented all financial monthlies, and if and when attended for approximately 12 years in his own tenure as a board member. I've never missed a meeting. I've done to my best ability to keep the water to the system, and I know nothing about parliamentary procedure. Tom Alphonse.
Mr. Alphonse, thank you for your comments. We heard you very well remotely, and so thank you. For the record, you've also stayed within a time limit I failed to alert you to, so thank you for that. The time is now, colleagues, for you to ask any questions of Mr. Alphonse you choose to ask. I'm looking to see if there are any questions. Commissioner Thompson, please.
Thank you, Mr. Alphonse. So I just want to make sure I heard your statement right. So these checks that were issued to you and to your son, they were signed by you and at least another board member? So they weren't just signed by you?
No, all checks have to have 2 signatures, always have been.
Okay, thank you.
Thank you. Other questions, colleagues? Of Mr. Alphonse, hearing, Commissioner Halt, please.
Thank you. So what I heard you say was that the water district owes you $70,000 of services that you have not received.
Correct.
How long has that debt from the water service been?
2018. Since 2018, we've had a major leak. Why that big expenses to the city, and me being on the board, knowing there's no money. I mean, I had to put money up just to buy parts to repair the lines that they're all emergency breaks at that point for about 7 years. So, yeah, it's been a battle.
So you've
Mr. Halt, please.
You've carried a debt for over 7 years of $70,000 for your community to make sure that it has water?
Yes, ma'am. And that's what it is at today. It didn't start out at that, it started at 0, and every year it accumulated, and just to keep water going to this system.
Thank you for your service to your community. Thank you.
Thank you. Any other questions for Mr. Alphonse? The time is now for us to discuss how to proceed on this matter before actually voting. So I'm interested in comments from colleagues about what our action could be today in light of what you've seen and heard from our investigator as well as our respondent. Commissioner Halt, please.
I would like to see us dismiss this and thank him for his service and his dedication to his community. Having a $70,000 debt to that you hold for your community is pretty admirable, in my opinion. Thank you.
Thank you.
You've heard the idea for a motion not yet made. Discussion, colleagues, about Commissioner Thompson, please.
I agree with Commissioner Halt on her stance to dismiss. My reasons are a little bit different. Number one, this sounds like us wading into a interboard squabble, and I hate that. And number two, I mean, I get that that his signature was on those checks, but it wasn't the only signature on the checks. So I'm inclined to agree with Commissioner Halt that we dismiss this.
Thank you, Commissioner. Vice Chair, any comments?
Yeah, I think this is like one of those complicated, very small government where it has to run in ways that some other governments can't run. And I feel like we would be penalizing an individual who has made specific sacrifices to help a government keep running. I'm torn because I do think, you still have to announce your conflicts of interest. You still have to follow the procedures. But I think education here can be helpful rather than penalizing. And so, if somebody made a motion, I'm not going to make it. I'd be inclined to vote for it.
Thank you, Vice Chair.
Yeah.
Any other comments? I would just say from my vantage point that I'm not sure this is the bottom line. If for me, it is a bottom line. This issue does not rise for me to the standard of a quote ethical violation unquote. So I would tend to be in favor of dismissal. That said, seeing no other hands, I will turn to Commissioner Halt for a motion, please.
I will make a motion to dismiss the case against Mr. Alphonse.
Executive, is that an adequate motion? Thank you very much. Any questions about the motion, colleagues, before we vote? Hearing and seeing none, the administrator will call the roll on item number 8. The motion is to dismiss.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Halt,
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Mr. Alphonse, thank you for being here, for both speaking to us as well as listening to us. We appreciate your patience with our schedule today. As you've just seen, and I hope heard, we have dismissed the complaint against you. So thank you for your service to your community, and I hope you have a nice weekend.
Thank you all very much. And if Mr. Sullivan has any more questions, I'd be happy to answer anything. But thank you again.
Thank you very much.
Thank you, Tom.
Vice Chair,
Can I request a short bio break?
ask executive.
Absolutely.
We will now take a short bio break, time to be determined. So I'm going to recess the executive session. The door will be open. We will convene in 5 or 6 or 7 minutes. Thank you, Vice Chair.
6 or 7?
I think Dave's with
You got to hear it. Well, I mean, you knew that you
Do it.
Okay, you're good, Chair.
You colleagues, welcome back. We will now continue under the previous authority, our executive session for December 12th, 2025. Our next item is number 9 on your agenda involving the respondent, Mark Thalacker, who is either in the room already or being admitted.
We just need a second to admit him.
Yes. He's been waiting in the virtual waiting room for a moment or a few moments.
Can we confirm that Three Sisters Irrigation District is not also in Astoria? Just for the record before we start.
Chair, I'm going to mute the room so we can admit. Okay, Chair, the respondent is in the room alone.
Blown too. I was like, what?
Colleagues, the time has now arrived for us to consider as the Ethics Commission the matters involving our respondent, Mr. Mark Thalacker. If I'm saying your name right, Mr. Thalacker, can you hear me?
Yes, sir.
Thank you very much. For the record, I'm Dave Fiscom, Chair of the Commission. The matter, we're going to now hear your matter. Our process is first to hear a report from our investigator, who is Mr. Sullivan. Please proceed.
Yes, thank you, Chair Fiscom and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda item number 9. This is a complaint against Mark Thalacker, board member and secretary treasurer for the Three Sisters Irrigation District. The complaint in this case alleges that Mark Thalacker may have been met with conflicts of interest when he promoted the district's floating solar project, which was described in loan materials as using floating high-density polyethylene HDPE floating modules. The complaint states that Mark Thalacker's business, CRAW USA LLC, is a manufacturer of HDPE products, the kind that would be used for the solar project. The information in preliminary review indicates that although Mark Thalacker's business, CRAW USA, is a HDPE pipe manufacturing business, it does not appear that CRAW USA is a business which manufactures HDPE floating modules for solar panel platforms. It appears that the CRAW USA facility does custom HDPE fabrication. However, it does not appear that the facility has ever manufactured floating HDPE models for solar panels, nor does it appear that the facility currently owns or operates the equipment necessary to fabricate them. It appears that the products manufactured by Mark Thalacker's business are substantially different from the HDPE floating modules proposed to be used for the TSID's floating solar project. Based on the information available in this preliminary review, there does not appear to be a substantial objective basis for believing that Mark Thalacker's actions to advance the TSID's floating solar project could or would result in a financial benefit for CRAW USA. The recommendation is to dismiss this case.
Investigator, any questions for our investigator colleagues based on the report you've read and or now just heard? Hearing and seeing none, Mr. Thalacker, this is your chance to make any comment you choose to make to us. Thank you for being here. And if you allow me to make a friendly suggestion to you, it is to be brief. Please proceed.
Yeah, I'm fine with the report. I mean, the charge was false, and we would have to spend, $1 million+ to buy equipment, and then we'd have to find a marketplace for it. So that's never been even considered or an intention. So I don't know why. I feel like the person is being malicious and trying to, use the ethics to basically punish me. So anyway, thank you.
Thank you, Mr. Thalacker, for being here. The time is now, colleagues, for us to talk about how to proceed and or make a decision. I'm looking for any comments. Hearing and seeing none. Vice Chair, do you have a motion?
Yes, for executive session agenda item 9, I move the commission dismiss the complaint against Mark Thalacker.
Colleagues, you've heard the motion with regard to item number 9. Questions? Hearing and seeing none. The administrator will call the roll, please. Item 9.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez is abstaining. Commissioner Mettler.
Aye.
Commissioner Jancy.
Aye.
Commissioner Halt.
Aye.
Commissioner McCauley.
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0 with 1 abstention.
Thank you, colleagues. Mr. Thalacker, thank you for being here and for your patience with our schedule today. You have now heard that we have dismissed the matter involving you and this complaint against you. Thank you for being here, and we hope you have a nice weekend.
Thank you. You too. Appreciate it.
Thank you.
Thanks. Bye.
Okay, colleagues, with a few moments for our technology process, we'll now turn to item number 10 involving, when you're ready, you tell me and I'll
Yeah, it says, looks like they're joining right now. I just need a moment of quiet so they can join.
please. I think we're ready to proceed to on our schedule, colleagues, item number 10 involving Melissa Unger, Executive Director of Service Employees International Union Local 503. My records show that she has not responded as to attendance or not, and her attorney, whose name I may not know how to pronounce, Andrea Play. Are you there, Andrea? You allow me to use your first name for the moment? Andrea, you may be on mute. Andrea, last name P-L-A. Andrea P-L-A. If you can hear me, can you unmute and respond?
Yeah, *6 to unmute.
And she did raise her hand.
I see the hand up. *6 to unmute.
Oh, Chair, if I can jump in, it seems like from what I can see on my teams that she's not allowed to turn off her mic and video.
She has been given permission to turn on her mic. She is calling in on the phone,
Okay.
so she will not be able to turn on her video.
Hi, can you hear me?
Yes.
Oh,
Thank you.
awesome. Okay. Yes, sorry. I was talking to my.
Can you
Pla.
say your name for all of us, Andrea? Pla?
Yes, and I go by Andy, so you can, if you want to just use Andy, that's fine.
Oh, thank you very much. Is your client good to be on today, Miss Unger?
No, it's just me.
Okay, thank you. The time is now for us to consider the item involving your client. We're happy for you to be here today representing your client. For the record, my name is Dave Fiscom, Chair of the Commission. The process is several-fold for us. The first step will be a report from our investigator. Then we'll proceed to eventually the time for you to make any comments you choose to make to us. That said, Investigator Fenstermaker, please, item number 10.
Thank you, Chair Fiscom, Commissioners. Casey Fenstermaker for the record. The next preliminary review in your meeting books today is agenda item number 10, case number 25-347 LCF, regarding a complaint that was filed by Representative Ed Deal, alleging that Melissa Unger, the Executive Director for the Service Employees International Union Local 503, which I'll just refer to as SEIU, violated lobbying law. The complaint alleges that SEIU provided constituent postcards to legislators that misrepresented individuals' support for House Bill 3838, and which contained statements of personal support for the bill that were known to be false. House Bill 3838 was a bill that proposed the establishment of the Home and Community-Based Services Workforce Standards Board. The complaint alleges that in 2 known instances, constituents reached out to their representatives to indicate they did not support HB 3838 and did not authorize the issuance of the postcard expressing their support. During preliminary review, it appears that neither SEIU's petitions or Facebook posts indicated that a postcard would be sent to a person's legislator if they filled out their information. However, it is not clear that the postcards contained a misrepresentation of material fact, since it appears that both individuals provided their information for a petition in support of HB 3838 prior to the distribution of the postcards to the legislature. Lobbyist is prohibited from making any false statement or misrepresentation to any legislative or executive official, or knowing a document to contain false statements to be delivered to a legislator without notifying the official of the false statement in writing. False statement or misrepresentation is defined to mean an intentional misrepresentation or misstatement of material fact. Material is defined to include that which may have affected the course of any proceeding if known prior to that proceeding. It's not clear that SEIU's postcards contained any misrepresentation, let alone a material misrepresentation. Our recommendation is to dismiss this case as there is not a substantial objective basis to believe that a violation may have occurred.
Thank you, investigator. Any questions for our investigator based on reports you've read and or just in the last few moments heard, colleagues?
I have a question.
Mr. Thompson, please.
Thank you. My question is around the, trying to find it here, the part of the complaint where one of the people who signed who supposedly signed a postcard had told SEIU the exact opposite of what the postcard said. Where is that? Where did I read that? I'm looking.
Maybe around page 3,
I could be.
the last paragraph.
Yeah.
3, you said, investigator?
The last paragraph.
Yeah, last paragraph, page 3. That is where I'm at. I'm curious. That doesn't. It seems like that SEIU is then aware that this person who supposedly signed this postcard did not support this bill. Curious how that factored in.
Sure. So I would say that there was an issue of timing. So the person had signed the petition first, and then, and when they signed the petition, they went into the language in the petition and tried to alter it, stating that they didn't agree with the HB 3838 and didn't support it, but the message still went out with the subject heading, "I'm in support of HB 3838," because it was an automated process. And so even though this person subsequently made statements regarding the fact that they didn't support HB 3838, there was still a record of them signing a petition in support of it. And they didn't, SEIU didn't verify that every person who had signed the petition continued to support, or not, yeah, continued to support HB 3838 through the entirety of the proceedings around that bill.
Thank you.
Mr. Thompson, follow up. I've got a question, Commissioner Held first, and then I've got a question. Mr. Held, please.
Thank you. So I'm very confused why we're not further investigating this, because it seems like there's a lot of things that are not really clear. If people did all these people sign something that we've seen that said they wanted to be on this postcard?
No, the document that they signed was a petition, and the petition did not indicate that a postcard would be sent to their legislator. What the petition indicated was that they supported HB 3838 and that would generate an email that would go out to their respective legislator. So they included their contact information and I think their zip code or their I think their zip code to indicate who their representative would be. And then this petition was emailed to their respective legislators. Again, there was nothing in the language of the petitions themselves that indicated that a postcard would be sent. But the complaint in this case is not alleging that the petitions were in some way defective. What they are alleging is that, in fact, the postcards that were generated and sent represent a misrepresentation of a known misrepresentation of fact. And it's not a known misrepresentation of fact because as far as SEIU is concerned, based on their petitions, these folks who had signed up were in fact in support of HB 3838.
So is the petition say the same thing as the postcard? Or is the postcard different wording than the petition?
The petition included significantly more information, to the best of my recollection. The postcard was much more brief, but as far as I recall, they both contained substantially the same information.
Any follow-up, Commissioner?
Yeah, thank you. I guess I just feel like we should be looking further into this because I don't understand all the details, and I want to really understand why these people feel they felt different than what the postcard said. I don't feel like I have all the facts to be able to say that this is not something I want to look further into. Thank you.
Investigator, let me say it my way, and I apologize if this does violence to your report, which I appreciate, but your investigation shows that some persons who signed a petition didn't know there'd be a postcard and might have disagreed with the postcard.
That's
They had a chance to consider it.
That's my understanding. They didn't realize that a postcard would be sent on their behalf to their legislators. So while they may have signed a petition, albeit they tried to alter the language in it, they still filed said petition, right?
Right.
Or had signed up in some other way in support of the petition. Yet there was just, they didn't know that a postcard would be sent. And so I think when this came to light, that postcards were sent with people's information on there, that generated concern because they didn't recall signing up to have a postcard sent out in there.
And then it's conceivable, maybe you don't know this, it's conceivable that some of the persons who were indicated as having sent a postcard hadn't seen the content of that postcard.
I'm almost
if that
certain.
requires speculation, please feel free to avoid the question.
No, I mean, I'm almost certain that they did not see the postcard.
Other questions, colleagues? Any comments on Commissioner Health's notions of needing more information? Mr. Thompson, Vice Chair, please.
I have no qualms with moving this to investigation if it would make certain commissioners feel like we need more information, or, I mean, you know, we're not finding a violation. If,
right.
You know, if people feel uncomfortable dismissing this at this point, you know, that it may be helpful to just feel like we're doing our due diligence on something that seems maybe complicated or unclear at this point. And I think sometimes in situations like this, it's helpful to move something to investigation to feel like we've done that due diligence. So I appreciate Commissioner Helt's comments, and this does seem like something that's maybe a little bit factually complicated. And I would have no qualms with moving this to investigation just to feel like we have a good look at it, and maybe we ultimately move to dismiss it at that point. But I'd be comfortable doing that.
What's worth, I would concur with that, especially with not passing judgment on that there was a violation. We're expressing our need for more information to be a little more crisp in the details, especially because maybe individuals involved in this didn't know what was being said in their name. I'm making that up. That's my words, not our investigator's words. So thank you for that freedom. So I would be inclined to move forward. Other comments, colleagues, in light of what's been said?
Do we need to hear from council?
Pardon me?
We need to hear from Andy.
Yeah.
I know.
Okay.
Yeah.
Okay, that's enough discussion for us for the moment. The next step in our process firmly is to hear from the respondent. In this case, it would be Andy Pla. Ms. Pla, thank you for being here. You're welcome to make any comment you choose to make to us. We would ask you to be as brief as possible and to the point. Thank you for being here. Please proceed.
Great, thank you. I just want to make sure you can hear me still.
We can. Thank you. Go ahead.
Okay. Thanks. I don't have any formal comment, but just to follow up on some of the questions and concerns that were raised. Yes, there was no explicit a postcard is going to be sent. The ask was sign this to send a message to your legislators, and the wording was nearly identical. I will add that the petition had a lot more information than the very short phrase in the card. I'd have to pull up the picture, but we provided that in our response of the card. It was a short statement, like essentially vote yes for, blank. But the petitions were a lot more extensive in the vote yes ask. And it said, the sort of the title on the ad on the Facebook that was mentioned was, tell your legislators. And so it didn't say exactly the format. And I understand that there was like an uncomfortability with seeing someone, seeing their name on a card versus seeing their name in an email. That's understandable. But in terms of the change in the message, the no came from, there's a general vote yes subject line, and then it has all of the information about why to support it. And then there's a piece where you can customize your message. And so we represent a lot of home care workers, right? A lot of people in the care industry. So it was an opportunity to share their own story. And what one individual did on one of the two petitions that they submitted was change the yes to a hell no in that customized message. And so we weren't going through and vetting who had customized that piece, because the subject line was vote yes, and the ask to fill out the form in the first place was only if you are in support. So just to clarify that, that's why there wasn't a follow-up on that piece. We only pulled that customized message as a part of this initial investigation, just to provide exactly what was submitted through those every action petitions. But they did submit, my understanding is that they did submit both, and only one had that custom message. I'm happy to answer any other questions if there's clarifications needed, but I believe we provided.
Thank you very much for being here today. Any questions for our respondent's attorney? Now is the time if there are such questions. Hearing and seeing none, the time is now for us to head toward a decision and then to make a motion at some point. Questions about how to proceed, comments, colleagues? Vice Chair, do you want to yield to somebody else for a motion, or would you want to make it?
I'm prepared to make a motion.
Thank you. Please proceed.
Okay. I move that the commission find there is a substantial objective basis for believing that Melissa Unger may have violated, okay. ORS 172.764, and that the commission should investigate accordingly.
Colleagues, you've heard the motion to move forward. Any questions on that? Please proceed.
Sorry, I may need to add a statute in there.
We're on a friendly pause.
I think that's correct. Is that correct, Susan?
I think it is.
Okay,
Thank you.
thank you.
For the motion, colleagues, ready for the question? I see no hands to the contrary. The administrator will call the roll. This is a vote on item number 10 involving Melissa Unger. Please proceed to the roll call.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Metler.
Aye.
Commissioner Jancy.
Aye.
Commissioner Halt.
Aye.
Commissioner McCauley.
Aye.
Chair Fiskum.
Aye.
Motion passed 8-0.
Thank you. Thank you, Attorney Pla. We appreciate your patience with us. We've voted to move forward, so we'll be proceeding to ask you and your colleague, your client, more questions. Thank you for your participation this morning.
Thank you.
Okay, we'll now move to item number 11. This individual is not appearing, so I'll wait for a second till we exit an entrance properly. Think we're ready to go. Item number 11 involving, if I can say this, I can't say it right, so I'll rely on our investigator to pronounce the name of this respondent. Investigator is Investigator Fenstermaker. Please proceed. Item 11.
Thank you, Chair Fiscum. Commissioners, Casey Fenstermaker for the record. Agenda item number 11, case number 25-396 LLG. Is regarding it's a preliminary review report regarding a complaint that was filed against Raluca Stoica, president of the Oregon Care Home Council, OCHC, alleging that she failed to report lobbying activities related to House Bill 3838, a bill proposing the establishment of the home and community-based services workforce standards. Oregon's lobbying laws require representative lobbyists to register in EFS, our electronic filing system here at the commission, within 3 days after exceeding the lobbying thresholds of either more than 24 hours of lobbying during a calendar quarter or spending an amount in excess of $100 lobbying during a calendar quarter. The complaint in this case was based on a number of Facebook posts of Raluca Stoica and other OCHC personnel at the Oregon Capitol and meeting with Oregon legislators and legislative staff. Raluca Stoica provided a detailed account of the time spent lobbying against HB 3838, which does not add up to either 24 hours or an excess of spending in $100. Therefore, our recommendation is to dismiss this case as there's not a substantial objective basis to believe that a violation may have occurred.
You investigator, you've heard the report. Any questions of our investigator colleagues? Hearing and seeing none, we're ready for a motion, Vice Chair. Item number 11.
For executive session agenda item 11, I move the.
Pardon me, yes, 11. Pardon me. Go ahead. Please proceed.
I move that the commission dismiss the complaint against Raluca Stoica.
For the motion, colleagues, I see no questions. The administrator will call the roll. Item 11, please.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Mettler.
Aye.
Commissioner Jancy.
Aye.
Commissioner Helt.
Aye.
Commissioner McCauley.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscum.
Aye.
Motion passed 8-0.
Colleagues, my friendly advice off the record to Ms. Stoica is if somebody thought, this is a retired lobbyist, 25 years, a long time ago, if somebody thought they were getting close to the hours or amount, register. It's fairly easy based on the registration system we employ, and it's always a better step I would submit to anybody to go ahead and register and avoid the appearance of not registering, even though we did dismiss, and I was in favor of that. Let's proceed with that comment to item number 12, involving Claire Hall, investigator. The person is not appearing. Our investigator is Fenstermaker again. Please proceed.
Thank you, Chair Fiscum. Commissioners, Casey Fenstermaker for the record. The next matter is a preliminary review report regarding Claire Hall, agenda item number 12, case number 25-423 PCF. As you may recall, the cases against the two other Lincoln County commissioners were heard in October, I believe, at the commission meeting. That's why we only have one commissioner with us, or one report regarding one commissioner today. In this case, Lincoln County Commissioner Casey Miller filed a grievance explaining that the commissioners voted to accept positions from a hiring freeze by email and through the NeoGov portal. OAR 199-050-0055 requires that all official actions of a governing body be taken by public vote and that the results of all public votes be recorded by name. It also prohibits the use of secret ballots. Finally, it requires that if written ballots are used, the name and vote of each governing body member must be announced during the meeting at which the vote occurs. It appears the commissioners violated this provision when they voted electronically. Additionally, it appears the commissioners convened a meeting because there was a quorum of the governing body involved. The quorum convened electronically. Commissioners decided which positions to exempt from the hiring freeze, and that is a matter within the county commission's jurisdiction. It appears they may have also engaged in a meet in private for the purpose of deciding a matter, specifically which positions should be exempted from the hiring freeze. Finally, it appears they failed to take meeting minutes of the alleged meeting or a recording of the meetings that they convened. Therefore, our recommendation is to move this case to investigation because it appears there's a substantial objective basis to believe that Claire Hall may have violated various provisions of public meetings law.
Thank you, investigator. Any questions for our investigator on this matter before us involving Claire Hall? For the moment, hearing and seeing none, Vice Chair, are you ready for a motion, please?
I move the commission find there is a substantial objective basis for believing that Claire Hall may have violated ORS 192630 subsections 1 and 2, ORS 192640 subsection 1, ORS 192650 subsection 1, OAR 19905000015 subsection 4, and OAR 19905000055, and that the commission should investigate accordingly.
You've heard the motion, colleagues. Any questions? Hearing and seeing none, the administrator will call the roll, please. Item T12.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Halt,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Chair Piscopo.
Aye.
Motion passed 8-0.
Okay, colleagues, thank you for that. We're now going to be considering items in some way, shape, or form, 13 through 17. Pardon me?
Through 19.
Pardon me. I apologize. Item 13 through 19, I'm looking for advice on how we're going to do this that our staff can apprise me of.
We got a bunch of people to ask.
Hold on just a second, because
We're gonna
that's
go
the
slow.
one
Oh,
that we had some changes to.
Yeah.
So, how would we like to proceed?
Okay, so it's a different attorney that wanted to attend than the one that we got the waiver for. Is that correct?
Yes, the other attorney I do see in the waiting room. That is correct. Not the attorney we got the waiver for.
Okay, I think you could invite the board members who are present to join. Do not enter the attorney yet. And once all of them are in the room, we can ask them to verbally whether they waive as to the new
The
attorney.
new attorney.
The moment my document says we have 3 persons who may be with us, pardon me,
it's right here. Oh, there's a flipped it. Yeah.
pardon me.
Here you go, Commissioner.
Use that.
Well, thank you very much.
Yep.
Okay, we have several individuals who intend to be with us in person, perhaps.
No, they're
All on teams. They're all on teams. Dr. Sammy, hard last name to pronounce. Christine Hawkins on teams. Therese Jones on teams. Luhui White Bear on teams. Bernard Wang on teams.
We're
And
replacing that person.
there's an attorney that will, so let's allow the others into the room for executive session, because they have all, as I understand it, waived or are consolidated, to use the technical term.
Right. However, the 2 who are not present, which is items, I believe 17 and 13,
Yeah, 17 and 13, yes,
we will need to consider their cases
Separately,
separately because they did not
right.
consent.
16 is also not with us yet.
Okay,
We did leave a message with them, but it went straight to voicemail.
okay, so
Okay.
we will consider those cases
Separately, so we consider those after we consider the ones who are with us. Is that fair?
Correct.
Okay, so we're now going to go through the process of admitting anybody who is waiting to be admitted.
Yep.
Christine Hawkins, Teresa Jones, Lahui White Bear, Bernard Wang, and Dr. Sammy Abrabu, if I'm saying that name right, which
Drava.
Allah, no,
Drava.
oh, pardon me, yes. Let's let him pronounce his name for us in a few moments. And then the first question for those persons is if they will waive confidentiality to allow an attorney whose name we did not have to join, who I'll pronounce in a minute once we get those persons in the room. Thank you for your patience with our schedule, colleagues.
I'm going to mute the room while Chris works on getting everybody in. And
Please do. No, wait for the high sign. The high sign is now given. Colleagues, the time has now come for us to consider matters involving the Benton County School District 509J. Several persons involved in that issue have indicated their intent to be on teams, and I'm going to go through their names in just a moment. And as I give your name, please indicate that you can hear me, and then we'll proceed. And I'll tell you how we're going to proceed today in a moment. The first one is Dr. Sammy. Dr. Sammy, please pronounce your last name for us.
Yes, sir. My name is Dr. Sami Al-Abdrab, present.
Thank you very much for that help with pronunciation. Ms. Hawkins, Christine Hawkins, are you on?
Yes,
Christine,
I am.
thank you very much. Therese Jones, are you on? Therese Jones, can you hear me?
Yes, can you hear me? Sorry, I think I
Thank
may have still been muted. I'm here.
No problem. We can't hear you. Thank you. Lahui White Bear.
Good morning, I am here.
Can you pronounce your name for me one time to make sure I can do it right next time?
Lahui White Bear.
Thank you very much. And the last name on my list is Bernard Wang.
I'm present and it's pronounced Wang.
Wang, sorry about that. I apologize for that. Colleagues and individuals on the line, I want to ask you all, and I'll ask for your individual responses to this. We've received information that a different attorney than we thought has asked to be with you to represent you today. Her name is Camila Osternick, if I'm saying that name right. In each of the cases of those persons who are here, we need to have you indicate that you agree to waive confidentiality to allow that attorney to be with you today for this proceeding. So is that adequate, Director?
That is, I would just clarify, I believe the attorney is representing the school district, not
the individuals. Thank you for that clarification. Dr. Sammy, if you'll let me not use your last name, do you waive confidentiality for Ms. Osternick to be here?
Yes, you may, and I have no objections for the attorney of the district to be here.
Thank you. Ms. Hawkins, do you waive confidentiality for this attorney?
I do.
Thank you. Ms. Jones, do you waive confidentiality for this attorney?
I do.
Thank you. Ms. White Bear, do you waive confidentiality?
Yes, I do.
Thank you. Mr. Wong, do you waive confidentiality?
Yes, I do.
Thank you. We will now admit Ms. Osternick to the room to participate in this process. We will wait a moment to allow that to occur. Thank you. Ms. Osternick, can you hear me? Camila Osternick, can you hear me?
Yes, yes, I can. Sorry, I was trying to find my mic.
No, no problem. Thank you very much. Okay, those of you online, those in the room, my room where I am in Salem know this, but I'll indicate to you that I am Dave Fiska. I'm the current chair of the commission. This is the time set aside to deal with matters involving the Benton County School District 509J. We have admitted 1, 2, 3, 4, 5, along with a new attorney. You have all waived confidentiality for that new attorney, so we're happy to have you all here. Our process is fivefold today. We will first hear a report from our investigator on these matters before us. We may have questions for our investigator, then we'll turn to you one by one. We'll ask you to be brief in your comments and to the point if that's possible to ask you, but we want to give you a chance to make comments to us you choose to make. May have questions for you. The last step will be for us to move toward a decision as a commission. That said, we'll hear a report from our investigator that will pertain to all individual matters before us. Investigator Fenstermaker, please.
Thank you, Chair Fiscum, Commissioners, Casey Fenstermaker for the record. The next set of cases are against Benton County School District 509J school board members. They're identified as agenda items 13 through 19 and case numbers 25-622 PLG through 25-628 LPG. I guess they were both LPG. Sorry.
PLG.
A PLG. Wow, I really screwed that one up. Sorry. Okay, in this matter, the complaint alleged that the Benton County School District 509J, otherwise known as the Corvallis School District, board members violated public meetings law. The complaint alleged that the meeting notice did not provide sufficient detail of what was discussed in executive session to allow the public to decide if they were interested in attending. The complaint also included allegations that the board members were required to disclose what documents were reviewed in executive session, which is not a requirement of public meetings. The meeting notice for the August 18th meeting cited an executive session pursuant to ORS 192.660 sub 2 sub F to consider information or records that are exempt by law from public inspection. The matters discussed were related to a matter that is confidential pursuant to state and federal law, including FERPA. Meeting notice for the August 18th meeting also included a special meeting, which the agenda item for was identified as action on matters discussed in executive session. Based on the conversation that occurred in the public portion of the special meeting, it appears that although what was discussed in executive session was confidential, there were certain limited details that could be shared publicly and could have been elaborated on in the meeting notice. Therefore, our recommendation is to move this case to investigation because there is a substantial objective basis to believe that the school board members violated public meetings law.
Thank you, investigator. Any colleagues, any questions for our investigator before we proceed to respondents? Mr. Thompson, please.
Thank you. Could you address the timing issue that's been raised on this complaint?
The timing issue. Yes, so I believe it is at least one person's assertion that the complaint was filed on November 22nd. That is incorrect. The date stamp for the complaints are November 23rd. We have 60 days from that date to complete the preliminary review report and have it signed by our executive director. That occurred on that was required to occur on November 21st, and it did in fact occur on November 21st.
Thank you so much.
Sure.
That answers your question.
It does.
Thank you, Commissioner. Any other questions from commissioners for our investigator or staff? Okay, hearing and seeing none, the time is now for us to hear from respondents. Just for the record, what I'm going to do is ask you to appear in any order you choose. Identify yourself for the record when you make comments to us. We'll allow all of you to make comments who may have questions then for one or all of you. As you speak to us, a couple things. Please identify yourself for the record as you make your comments, and then with respect and in a friendly way, I'm going to try to hold each of you to no more than 3 minutes. All that means is we need you to speak crisply and clearly to the points you want to make to us, and thank you for being here. So please proceed. Anybody who chooses to start, Executive.
Might be a good idea to start with the attorney for the district.
Which is fine with me. So Ms. Osternick, if I'm saying your name right, we'll turn to you first. Please proceed and feel free to correct my pronunciation of your name.
Thank you. Thank you to the commission for allowing me the opportunity to speak on behalf of the district. My name is Camelia Osterink, and I am an attorney with the Hungerford Law Firm here on behalf of the Corvallis School District. So the district, through their board secretary, sought counsel regarding the appropriateness of the executive session in terms of the subject matter and how to prepare the notice for the executive session. The record shows that the notice for the August 18th meeting was sent to the local newspaper on August 14th. The district received a report that it was posted in the newspaper on August 16th. It was sent on the 14th and it was posted on the 16th. Between when the notice was sent out and when the meeting was held, the district did not receive any inquiries about the notice. No members of the public or media reached out for additional detail about what would be discussed at that meeting. That executive session was in fact held. The commission has already, as noted by the investigator, has already held in the preliminary review that the notice and the basis for the executive session were proper. So it's certainly come as a bit of a surprise that now the commission is looking at something that was not necessarily specifically raised as part of the original grievance in the matter. After the executive session, the board then moved into open session. The entirety of the open session was both streamed and recorded. That video was streamed live, and 89 individuals streamed that live. It was then posted online the following day. After the meeting, one of the newspapers ran a local story on the discussions held and the actions taken during that meeting on August 18th. So ultimately, the complaint that was filed with the district and subsequently addressed by the commission was focused on the executive session itself and not the subsequent public meeting. And as previously noted, the commission found no error with the executive session. In other words, this appears to be a bit of a problem in search of a solution. A solution in search of a problem. Here, the public was notified about the meeting in advance. No members of the media or public indicated prior to the meeting that any additional details about the meeting were necessary. Members of the public live streamed it in real time. The video of the meeting has been publicly available since that day, and subsequent news articles which cite discussions from that meeting have been written after the fact. No member of the public has since filed a complaint that the public meeting itself, as opposed to the executive session, was improperly noticed or deprived them from knowing whether or not the public meeting would be of interest. So the situation presented a single issue executive session followed by a meeting that referred to that very single issue. So we would argue on behalf of the district that this was a sufficient list of principal subjects to allow the public to recognize the matters being discussed and determine if they were of interest to anyone attending the meeting. Thank you for your time, and I'm happy to answer any questions as I can.
Thank you, Ms. Osterink, and I apologize for fouling up your name once, and I may do it again, but let me just change the process here, and I will call, for ease, I will call on the names I have in the order in which I have them for your comments, if you choose to make comments to you. And I will refer first with first name only because I can't do your last name yet. I apologize. Dr. Sammy, it's your turn. Please proceed.
Thank you. For the record, my name is Sami El Adrabo, board member from Corvallis School District, chair Fiscom, Vice Chair Payne, members of the Commission, Executive Director Myers, thank you for the opportunity to speak with you today. I want to begin thanking you for your role in impartially and fairly and effectively administering Oregon government's ethics laws with an emphasis on education and achieving your mission. I appreciate and thank you for the care and consideration you give this matter. I would like to focus on three narrow but critical issues that go directly to whether this matter should be proceeding to investigation. First and most importantly, reliance on the Commission on guidance. On December 8th, just days after the preliminary review was issued to the respondents, I faced an identical question in the context of another public body meeting. As I did in the matter before you, I consulted with the public body legal counsel. I also attended the OGEC's mandatory public meeting law training again on December 8th and asked a direct question about how to notice action following executive session when confidentiality limits specificity. The written and verbal guidance from OGEC staff was clear. General language such as action on matters discussed in executive session, particularly when paired with executive session citation, is permissible and commonly used. This is exactly the practice, longstanding practice now being questioned. Relying on good faith on that guidance, I attended another meeting on December 9th, the following day, using the same notice structure consistent with OGEC's training and interpretation of the law that's currently we are finding as a substantial basis for investigation in this matter, which I respectfully disagree with. Second, the statutory authority and timing. I appreciate the clarification from the commissioner. I respectfully disagree with the investigator assertion earlier today, and happy to speak to the evidence to that. The report was not, in fact, issued to the respondents until after 60 days period has expired. Third is the scope and notice. The district attorney explained that perfectly, so I want to just share my agreement to it. In closing, public officials must be able to rely on commission's training and guidance. If conduct that is taught as permissible can later be considered as the basis for an investigation without rulemaking, without notice, without prior precedent, it places officials at an impossible position that undermines confidence in the training process itself. I respect this commission on its mission. And I want to be clear, I'm grateful for the guidance I have received over the years. My request today is not about avoiding accountability. It's about clarity, consistency, fair notice, and adherence to statutory limits so we can balance between confidentiality of those matters that we are considering in executive session and abide by public meeting law. And happy to answer any questions.
Thank you, Doctor. Appreciate your comments. We will turn next to Christine Hawkins. If you have any comments to make, now's your turn. Please proceed.
I do not. Thank you.
Thank you for being here. Therese Jones, any comments to make to us beyond what your colleagues have already shared with us?
No, pardon me. I think that Sammy summarized the key points that I also have identified. I would reiterate that I am unclear on how it is determined that the timeline for notice was met. Based on the dates of communication that we received, the December 4th email letting us know that this was in fact going to a committee meeting appears to be outside the window of the 60 days. And I would ask for a more complete breakdown of how we are arriving at different timelines around the initial complaint filing in September and December 4th being very clearly 60 days later than that. Thank you.
Thank you for your comments. Ms. Whitebear, this is your time if you choose to make any comments beyond what you've heard. Thanks for being here.
Yes, hello and good morning again to everybody. I'm thankful that I'm able to offer a few words. One of the things that has not been shared that I had spoke with one of my board colleagues. Oh, I need to introduce myself. I'm sorry. My name is Louis Whitebear for the record, and I'm the chair of the Corvallis School Board. I spoke with my colleague Judah Largent, who was also who also received the notification on December 4th. He cannot be here due to his own work schedule, which is respected, obviously. But he did not receive the initial preliminary investigation notice that the rest of the board did. And I'm a little bit confused why 1 out of 7 of us did not receive notification of a preliminary investigation. The first he heard of it was on December 4th. And so makes it a little bit difficult where 6 of us are being held accountable for something that, a claim that was made against the entire board. And so I was a little bit confused about that part. And so was he when he received it. And I can't speak fully for him, but I did say that I would share that point for the commission to know about. In addition to the timeline feeling unclear in the statute, when we notify somebody that is under investigation or a preliminary investigation, that is usually when something closes. So it's not very clear in the statute that it's when the director signs a document, and it fills outside of the timeline as well. When it was 13 days later, I believe, when we received the notification. The other piece is I feel a little bit blindsided by this preliminary investigation finding because it was not part of the initial complaint. So as board chair, when I had worked with the district staff, we were not able to address the piece of the second agenda item, which the preliminary finding is based on. This is the only time that I know of when I asked for clarification if there was other examples when the Ethics Commission isolated board agenda items when there's a single topic on the agenda. That's the only thing there. It would make sense if there was other items, but there was only one agenda or one topic on the agenda. It was confidential under executive session. And so the preliminary finding is not actually on the original complaint for 1. And for 2, it completely isolated connected agenda items when that was the only topic that was in the on the agenda that was properly noticed. So half the agenda it said it was perfectly fine, but it's the same topic. So it was really unclear how we could have even resolved that under the guidance as it's been explained by my colleague in the trainings that we receive. We were under good faith following it, especially when it's the only thing that was on the entire agenda. And so that's a couple of things I wanted to share with the commission. Thank you so much for your time.
Thank you, Ms. Whitebear. The last person on our queue would be Mr. Wong. If you have a comments to make, Mr. Wong, now's the time.
Yes, I do. Actually, I'm gonna cut my talk a little bit shorter. My name is Bernard Wong, and I am a school board member in the Corvallis School District. I'm also the most junior board member. This is my first term. And as a board member, I rely on district staff, legal counsel, and on the training materials that trace back to this commission and the Attorney General's office. And these materials tell us to provide timely notice to the public, give the date, time, and location of the meeting, identify that an executive session will be held, and cite the specific statutory authority, and ensure that any final action is taken only in open session. We did all those things on August 18th. And as a new board member, a new elected official, relying on my training, relying on what I understand of the statute, I think there are a lot of points here we need to clear up, specifically in cases relating to executive sessions where the information is protected. If the commission ultimately concludes that more descriptive language is required, even in circumstances involving records exempt from disclosure, I respect that interpretation, but I would ask you to view my conduct as that of a board member acting in good faith, relying on statutory framework, training provided, and navigating a principal subject standard that does not explicitly address how far one can go when the subject itself is protected. And going forward, I would welcome more concrete examples or model language from this commission for notices and agendas in situation involving ORS 192.6602F and similar provisions. I would gladly support incorporating that guidance in my district so we can better harmonize transparency with legal obligations to protect confidential information. So to me, this is one of those matters that you mentioned, Chair, in your opening statement that probably needs to be clarified and tightened up. Thank you. I stand by for your questions.
Thank you, sir. Thank you all for your comments. And thank you all for abiding, roughly speaking, by our time limits. We appreciate that, given our agenda today. Now's the time for commissioners to ask any of you any questions commissioners choose to ask. I'll see if my colleagues have any questions. We'll proceed. So stay on the line with us, respondents. Any questions? I have a question for our executive and/or investigator, but I'll yield to Commissioner Halt first.
Hi, thank you, Chair Fiscom. It sounds like they've followed every one of the procedures. It sounds like they've done our trainings. So I'm confused what they have done that needs to be further investigated.
Will it yield to our investigator and/or the executive for answers to that question? Investigator, please proceed to answer if you have an answer.
Sure, it's not necessarily that there's any additional information that we need to collect or any additional investigation that actually needs to be conducted. The reason that we would recommend moving this to investigation is because we believe there's a substantial objective basis to believe that the meeting notice did not provide sufficient specificity as to the information or agenda items that were going to be discussed during the special meeting. Instead, the meeting notice relied on just saying action on matters discussed in executive session, which doesn't provide any type of indication as to what action could have been taken, what matter was under review, what, anything about what was discussed or what was going to be reviewed. And so when you listen to the meeting and you listen to the motions that are made in open session, they specifically refer to a complaint and they specifically refer to policies that were implicated by that complaint. And so there is information that they could have shared with the public on their public meeting notice to more fully educate the public on what they were going to talk about during that special meeting. So that's why we believe it should be moved to investigation, because we believe that a violation occurred.
Thank you, investigator. Executive, please.
And I want to clarify what she just said, that we're not suggesting that they needed to identify the complaint, the student. I don't want to go anywhere near a FERPA violation. What the AG manual says is that the list of subjects to be considered needs to be specific enough to permit members of the public to recognize matters in which they are interested. So the question, and I readily admit, as Dr. Al-Abdraba, and I probably mispronounced that, but I try, said that this is somewhat of a difficult topic as someone who represented school districts in the past, that coming up with the right language for the agenda when you have to be careful, especially about not disclosing the confidential information. But it should be, at least gives the public an idea. Simply saying you're going to vote on something that was discussed in exec session doesn't give any context to what matters you might be taking up. And then I'll wait until we address that question. I would like to address the timing issue at some point.
I would like you to. I have a couple questions. I'm going to ask them, and then if Commissioner Helt's hand is still up, we'll turn to her. I'm going to presume the answer to this question is yes, but as best you can tell and know, does our training regime encompass what you just said about the kind of notices that are appropriate for executive session?
The training, I don't believe the training specifically talks about, like, the example of what to say in a notice after the exec session. It does talk about that the notices need to be specific enough to identify matters.
Clarity up to a point is
Right.
what
I think more often it would be a specific question from someone during the training that may have elicited further comment.
Thank you. My second question is, if this school district relied on either or both of its own legal counsel advice or your training regime, what effect does that have on this issue?
So the penalty matrix provides that a governing body members who are relying on the district's counsel advice we would be limited to providing them a letter of education. Frankly, whether that was at issue or not, this is the type of case that if the commission moved forward, our recommendation would be at most a letter of education.
Those two concepts I mentioned would fall into the category under our matrix of mitigating factors. If that's the right label. And the matrix would not come into effect unless we actually voted to investigate. It's at that point that the matrix is involved. Okay, thank you for those answers to my questions, and I will come back, Executive, to your other comment. First, Commissioner Hill, another question?
Yep, thank you. Thank you, Chair Fiscom. I'm curious as to, it sounds like they were looking for the answers from us, but they couldn't find them. How do we fix that for the future so that we are telling them the specifics? Because I heard a lot about the procedures, but it sounds like the procedures were all fine. It was the wording of the executive session notice, not the timing of the executive session. So should we also be limiting what we are, if we choose to move forward for education, should we limit what we are moving education forward on? Because it sounds like the timing and all of the notices were done properly. It's just the wording. Am I correct?
Executive, please.
Yes, the report's recommendations were simply that the exec session notice for this session, it was proper under F and the discussion was proper under F. And that, so really the only issue for moving forward was the notice of what was going to be discussed once they came out of exec session.
Thank you. Any other questions from colleagues? There may be some more questions at some point. I want to give the executive a chance to make any comments she chooses to make in light of commentary about what I'll label as, quote, timing, unquote.
Okay, so what the statute says is the preliminary review phase, and this is ORS 244.260, subsection 4A. The preliminary review phase begins on the date the complaint is filed and may not exceed 60 days. Where was it? Blah, blah. I just lost my place. I apologize.
Oh, we're pausing.
The preliminary review phase begins on the date a complaint is filed or the date the commission decides to proceed on its own motion and ends on the date the executive director completes the statement of facts determined under subsection paragraph D. So in the commission's process, the complaints get opened. I review them. I have 2 days to open the complaint. From the date the complaint is submitted to the date I sign the preliminary review report, that has to not exceed the 60 days. The commission meets monthly, and the commission may not meet within that 60 days, or it'll meet way early or afterwards. So once the preliminary review report is completed and signed by me, it is held as confidential until it can be presented to the commission at its next meeting. Once that meeting agenda is prepared, the reports are given to the individual respondents, along with information on how to attend the meeting. That is what took place in this case, and it's consistent with all cases that come before the commission.
Make just a comment on a question, half comment, half question on that. The effect of that timing, thank you for that clarification based on the statute. The effect of that is that a respondent would not receive information about an issue within 60 days. It'll be often somewhat after 60 days because the 60 days applies to our work as opposed to getting a document to the respondents. Is that
correct?
If I said that badly, please correct my
No, that is
commentary.
That is correct.
I'm not defending us. I'm just saying that the 60 days applies to our work as opposed to the dissemination of our work.
Correct.
Okay, thank you for that clarification. Colleagues, any other questions? Any commentary from commissioners about how we ought to proceed in this matter? Dr. Adraba. Dr. Sammy, if you have a comment, this is your time to make it quickly, please.
Thank you. I really appreciate it. So I'll be very brief and thank you for the mindful consideration. I will share in the chat for the sake of specificity, and I understand those in person may not be able to read it directly, but I shared also with the executive director the exact in writing answer that I got. Those answers are verbatim what the investigation is considering as substantial basis of investigation. So I just want to be clear, it was a very specific verbatim wording that was considered as appropriate. And what I'm sharing here is being considered now as substantial basis to investigate. So happy to delve into detail if you want, but I just want to highlight that as a very matter of concern. In terms of timing, I want to just assert that Johnson versus Employment Division of 1983 and McDowell versus Board of Dental Examiners of 1980. And there's some other statutory supports from ORS 183-415 and Federal Due Process Goldberg versus Kelly 1970. They all assert that internal process without communicating to affected parties is not effective to fulfill statutory requirements. And ORS that governs the Ethics Commission does not detail that the signature of the executive director fulfills the 60 days. So since it was silent on it, I really want to lean in on a case law that really asserted that any internal process of an agency is not complete unless affected parties has been communicated with.
Thank you, sir. Appreciate it. Commissioner Resendez Gutierrez, I see your hand up. Please.
Yes, thank you, Chair. I'm troubled by, guess, the lack of clarity regarding what actually needed to be included in the notice in light of the actual executive session provision that applies here. So if it's to consider information records that are exempt from law from public inspection, it seems like the notice language isn't universal for every single specific provision under 192.660, because that one seems like it might carry a different level of confidentiality that some of the other subsections don't.
Executive, and then Ms. Whitebear, in just a moment, I'll call on you one more time, but reasons for time, I want to ask you to be brief in a moment, but first, Executive, please.
Yes, so the notice as to the exec sessions themselves, obviously you have to, identify the specific provision and reason for holding the exec session. The question here is, if you are taking action afterwards in the public session, what kind of notice do you have to take that action? So I agree with you, Commissioner Resendez Gutierrez, that it is difficult because you still have to maintain the confidentiality that comes with that subsection F provision. The question here would be, could they have provided more information by saying to discuss a complaint without identifying anything about the complaint or to discuss these school district policies. That is potentially possible. In terms of the Dr. Aladraba's attendance at the December 8th training, and if we are not providing clarity in response to the question asked in the training, that may be something we need to come up with a better answer for. I simply want to clarify that all was after the report, after the session and everything else. So that is.
Thank you. Any other questions briefly by commissioners for anybody on the witness table? Commissioner Resendez Gutierrez, do you want to add? Oh, there, I see your hand up now.
Yes,
Another question, please.
Thank you, Chair. No, it's more as a follow-up. I mean, I would appreciate, I appreciate the answer, Executive Director. I think that if that is truly what our position is, then there's a training opportunity regarding certain subsections in 660 that I would treat similarly. So F being one of them, the H would be another one that I think kind of gets into that extra confidentiality piece that might not be as clear for people to not destroy the reason why they're in executive session, right?
Yes.
Thank you, Commissioner. Our training staff has caught my eye and they are considering your viewpoints. So thank you for making them. Ms. Whitebeer, one last time, please.
I just wanted to read the question exactly how I sent it to the investigator that I asked about this. It says, do you have examples of other cases where the Ethics Commission isolated board agenda items to base a finding on when the entirety of the agenda is on the same executive session and where the subject matter is confidential that you can share with me? And the answer is, I am unaware of any examples that are that specific. It has not been specified why these agenda items were isolated, and when this is not common practice of the Ethics Commission. And that's why it's very confusing for us. And while the training that my colleague has referred to was after we received the letter, that does not change that. That is what we are being trained on prior to this. And so we've all taken these trainings and follow it with good faith. It wasn't unclear in the answer. It was, yes, you followed the right thing if you read the text of what Sammy has shared in the chat. And so I just wanted to share that it's really difficult as somebody who highly respects procedural laws, our roles as public officials, when we are being given conflicting information and not clarity on why this happened in this manner when it's never happened before with the commission. And it's a little bit disheartening to, as a public official that strives to operate within very strong ethical frameworks, and somebody who is oftentimes looked at as unknowledgeable, to be quite clear. So I take extra steps in ensuring I follow rules really well. And it's I'm not sure why this unfolded in the manner it did when we addressed all the complaints from the complainant as it was. And I would really hope that the commission really thinks about that, in addition to our colleague that was not included in the preliminary notifications of the complaint that came into you all.
Thank you, Ms. Whitebeer, Executive.
Just to clarify, Ms. Whitebear, because he is not present, we have to address that notice issue in his case separately, because we will do the cases for those who are not present immediately after this. So that will be something that gets addressed when his case comes up.
Yeah, there will be two individuals whose cases will be considered by us.
We can.
You can't.
I understand, but there'll be two cases unnamed that will be considered separately for the record, without names attached to those. Vice Chair.
Can somebody read what was put in the chat regarding the training? Because I would like to be able to see that, and I'm not privy to the chat.
Oh, yes. I can share.
Happy to
Ms.
offer that,
Hafner?
Commissioner.
Hang on a second. Ms. Hefner will read it for us.
It says, a question on noticing meeting with a decision following an executive session. 1, what is the guidance on how to notice a meeting with a final decision after the executive session? Let me share my screen while I do this, actually. Just one moment. Let me see if it'll let me pop the chat out so that it is bigger. Sorry, Chair. It will. Here we go. Okay, so question on noticing a meeting with a decision following an executive session. 1, what is the guidance on how to notice a meeting with a final decision after the executive session? 2, should you list final decision following the executive session? 3, how specific or general can it be? And would it be sufficient to reference on the agenda making an action following executive session, citing the specific executive session? Examples of notices: A, executive session, cite ORS 192660, subsection provision, then list action on matters discussed in executive session. B, executive session, cite ORS 192660, subsection provision, then list action if needed. C, executive session, cite ORS 192660, subsection provision, without listing any follow-up agenda items, but once returning to open session, the governing body votes on the matter discussed in executive session. Written answer from OGEX staff. A notice that includes a public session after an executive session needs to meet the requirements for a public meeting notice. So it would need something listed as the subject of discussion for that public session. 2, you could list final decision from the executive session discussion, but there's no requirement. Some government bodies may not do this because they may not always have a decision to make after an executive session. Number 3, it can be general, specifically if the subject matter was something confidential. I think your examples would all fit the requirement of listing a subject of discussion, but I do think B is helpful in terms of showing that an action could occur. But again, since there aren't any specific requirements on this in public meetings law, it's up to your governing body on how you'd like to do it. Would you like me to continue with the verbal answer as well, Chair Payne? Or, sorry, Vice Chair Payne.
I can read it.
Okay.
Think what you've done. Thank you, Ms. Hefner. That's adequate for now. And we are reading what you put on the screen, so we'll pause just for a second. And I've got 2 hands up from commissioners. We'll proceed in just a moment. Mr. Thompson first, please.
Thank you, Mr. Chair. Just for the record, I went back and reviewed the statute that Executive Director Myers quoted on the timing issue, and it does clearly say that the 60 days applies to when she signs a report. So I don't think there's a timing issue here. That said, though, I think this group made a valiant effort to comply with the executive session posting requirements on a confidential issue. So I'm not prepared to move this any further at this point. I think they made a good faith effort. And maybe there's some work we need to do on our end, maybe not, to clarify, but for now, I'm convinced that they made a good faith effort to comply with the rules that we have set forth.
I would concur with that, and with this additional proviso or comment, I think that I would consider 2 things which we can't firmly consider until we get to an investigation, but that is to the extent that these citizens, public official citizens, relied on our training, say they relied on our training and say they relied on legal counsel advice. I think those are, to the extent, mitigating factors, which we can't consider formally, but are in my mind for consideration. That said, I'll turn to one last time to Commissioner Halt, please.
Thank you, Chair Fiscom. I just wanted to reiterate the same sentiments that have been said. I think we have some really great school board members before us today that really take their role to their students very seriously. And I think that we have all had a lot of education today on what we need to do to make sure these notices are putting things forward to the public correctly. And there may be some changes that need to be happened inside of the direction that we give. But I really think that to Commissioner Thompson's point, that this has been satisfied from my perspective. And I just want to say thank you to these school board members for serving. Thanks.
Thank you, colleagues. I think we're heading toward a decision. I see no further hands raised. Vice Chair, are you ready for a motion, or would you prefer somebody else make it?
I am, however, I now understand that as a group, if we're prepared to dismiss, we can do so as a group now.
I think it would be easier. We are getting to that. I don't have the appropriate language drafted yet. I think so we will proceed individually, unfortunately. Or you could create.
We'll have to proceed individually when time comes for a vote, as I understand it.
But I thought we could now do so as a group if we're moving to dismiss.
You can. You have to give everyone the option to vote on the cases separately if they want, but the commissioners.
So the easiest option is to just vote on each one individually.
Not for me. It is not the easiest option.
I didn't think it was easier for the current vice chair.
I would prefer to move on this group, to dismiss on this group as a group.
As a group?
And
Legal counsel,
I can still say agenda items.
Name the agenda item.
Name the agenda items individually, but then we vote on them all together. Is that appropriate?
Yes. Nodding ahead, yes. Thank you.
I will. Okay. I will do my best to make an appropriate motion.
Thank you.
Okay. For executive session agenda items 14, 15, 16, 18, and 19. I move that the commission dismiss the complaints against those respondents.
Thank you. That motion is
I need
adequate.
to
Legal
name
counsel.
Okay.
Individuals.
I withdraw the motion I just made.
Just amend it, yeah.
I will amend the motion. For agenda item 14, Dr. Sami Al Abdraba. For executive session agenda item 15, Christine Hawkins. For agenda item 16, Therese Jones. For executive session agenda item 18, Lahui White Bear. For executive session agenda 19, Bernard Wong. I move that the commission dismiss the complaints against those respondents.
Any questions about the motion you've just heard, colleagues? I'm going to assume there aren't any because I see no hands. Roll call vote on the motion just made for items by number 14, 15, 16, 18, 19. Please proceed.
Commissioner Mettler.
Aye.
Commissioner Jancy.
Aye.
Commissioner Halt.
Aye.
Commissioner McCauley.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Okay, respondents, thank you for your patience with our process today, for being here and for sharing with us in the spirit of candor and respect your comments. We appreciate hearing from all of you. Thank you for being here with us. You now know officially that this matter involving you has been dismissed. Proceed to have a good weekend. Thank you for being here, and we will let you exit now with waves. Goodbye. Thank you.
Thank you very much.
Thank you for your time.
Thank you very
Okay.
much.
Let's allow the process to proceed before we move on a couple more items yet to be named. Thank you.
Thank you for accommodating my motion.
Where was that last meeting when there was like 26 of them?
You need a glass of water.
Yeah, you need a glass of something.
After that,
It took some arguing, but
yeah.
We finally convinced our legal counsel the right move. Thank you very much. Oh, that's, we're on silent. That's
enable her to read them all out and then make the change.
Yeah.
Yeah, we still have to do the other two.
Got two.
Okay.
We just need to let the chair know when we're ready for
Yeah.
those.
Move them out. There's neither of these two others are appearing.
Former Commissioner.
Are they not
Jones is
appearing?
Here.
They're not
He has
appearing.
a short window of time, just so you know.
Read, get probably break.
Okay, we should be good.
Okay, colleagues, what we're going to do now is consider the item involving Judah Largent from the Benton County School District. I'm going to take the role of chair to presume we have heard the report from our investigator. Unless he needs to make a correction or addition to the report, please proceed if you do, Investigator Fenstermaker.
No, I just didn't know if that was acceptable since these are distinct cases.
Oh,
Well,
pardon me.
I think you need to hear it separately, Mr. Largent, Judah Largent's case, but I think
That's fine.
he needs to provide some clarity on the notice.
Please proceed. Thank you for the clarification.
Okay. So the complaint alleges that the Benton County School District 509J Corvallis School District board members violated public meetings law. The complaint alleged that the meeting notice did not provide enough detail of what was discussed in executive session to allow the public to decide if they were interested in attending. The complaint also included allegations that board members were required to disclose what documents were reviewed during executive session, which is not a requirement of public meetings. The meeting notice for the August 18th meeting cited an executive session pursuant to ORS 192.660 sub 2 sub F to consider information or records that are exempt by law from public inspection. The matters discussed were related to a matter that is confidential pursuant to state and federal law. The meeting notice for the August meeting also included a special meeting, which was identified as, and the agenda item was identified as action on matters discussed in executive session. Based on the conversation that occurred in the public portion of the special meeting, it appears that although what was discussed in executive session is in fact confidential, there were certain limited details that could have been shared publicly on the meeting notice to comply with public meetings law requirements. Therefore, the recommendation is to move this case to investigation because we believe there's a substantial objective basis to believe that public meetings law was violated. To Executive Director Myers' comment on the meeting notice issue regarding Judah Largent, we have a record that an email was sent to him on September 23rd. It's sent to the same email address that he emailed me from yesterday to tell me that he had never received the complaint. So we do know that initially it was sent to the wrong email address, but we quickly corrected that error and resent it out. So we have every reason to believe that in fact he received the complaint based on the contact information that we have for him, I believe from EFS or from their website.
Thank you. Questions for our investigator?
So in the, sorry, Chair,
Please,
may I be
please,
recognized?
please.
So in the Google Drive, we have notice sent to certain individuals, but I don't think we have the notice sent to him. So I have a notice sent to Tom Henderson, but I don't have a notice sent to him. Is there a reason why we have notice sent to some respondents, but not to others?
So the actual email that was sent to him from us isn't included in there. What they get is a copy of the printout from our system. And so when a complaint is filed against one individual on a governing body, it's replicated across all members of the governing body. So it tends to show up in the same, with the same original respondent name. And the original complaint was in fact filed against Judah Largent because he was the one who made the motion during the special meeting. Does that answer your question? I mean, I can pull up the copy of the.
No, I mean, it's fine.
I don't think the emails that we send them are exhibits to the complaint.
They are not.
So they wouldn't be up there. However, we maintain in the case file copies of the emails where we send the complaints to everyone.
And if that is something that you'd like to see going forward, included as an exhibit, we can certainly do that.
I think if there's a dispute, if regarding whether somebody received notice, it might be helpful to then have that notice in the Google Drive, just so we can see that it was properly sent.
Correct. The first time we had any notice from him that there was a question about this was he emailed Casey late yesterday.
Got it. Okay, thank you.
Colleagues, questions further? I have a question which I'm going to decline to ask because if I asked our legal counsel would come close to shooting me, so.
Now I'm curious.
It would be,
So are the rest of us.
How do you want to proceed, colleagues? Looking for a motion? Vice Chair, you ready for a motion? If you're not, I'll find somebody who is.
Yeah, I guess I'm just without having, I mean, there's a dispute regarding notice and we don't have that information before us. I'm a little just not having that information before us when there's a dispute regarding notice.
What I would only say in response, and I don't have all the information at the forefront of my thinking, but it sounds to me like we have records that says we tried to communicate with him as best we could, and there was a mistake and we tried to correct it. So effective notice was provided, I would contend, but I'm happy for corrections.
And keep in mind that all of the other related cases just got dismissed. So, but
That's what I was going to say, but I knew our legal counsel wouldn't let me say it, so you did, so he can clap for you.
Got it. Got it. Okay. Yes, we would dismiss on other grounds anyway. Okay.
That's.
Okay. All right, I can proceed.
Please.
For executive session agenda item 13, I move the commission dismiss the complaint against Judah Largent.
Heard the motion, colleagues. Any questions about it? Hearing and seeing none, the administrator will call the roll. Item 13.
Commissioner Jancy.
Aye.
Commissioner Halt.
Aye.
Commissioner McCully.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Mettler.
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Do we next move to item 17?
Item 17.
Director.
I need to give a full report to
Item 17 will be, and our investigator Fenstermaker will make a brief report on that item, please.
Sure. This complaint was filed against Corvallis School District board member alleging violation of public meetings law, specifically that their public meeting notice did not adequately specify what would be discussed during the public portion of the meeting. The executive session held immediately prior to the special meeting was held under ORS 192.660 sub 2 sub F to consider information or records that are exempt by law from public inspection. That was appropriate and no findings there. The question that resulted in a substantial objective basis to believe a violation may have occurred was the fact that the agenda item in the special meeting was simply listed as action on matters dismissed in executive session. And based on public meetings law and the details that are written, we believe that's insufficient to meet public meetings law requirements. And recommend moving this to investigation.
Questions, colleagues? Vice Chair.
For executive session agenda item 17, I move the commission dismiss the complaint against Shauna Tomini.
Please call the roll, Administrator.
Commissioner Halt.
Aye.
Commissioner McCully.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Mettler.
Aye.
Commissioner Jancy.
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Okay, colleagues, with regard to the time frame, I would like to forge ahead on at least one more category or two, unless Director, you want to do lunch now.
I believe that former Commissioner Mason is here and has a limited time to join us for lunch. You want to do lunch now and then
We can recess the
Resume it.
executive session as far as I'm concerned, come back and do the two other matters under the current authority and then cite new authority for the last item. If that meets with your approval, that's what we'll do. And we can go greet Commissioner Mason, and it's possible that Mr. Person may be here as well. Is that fair?
Yes.
Okay, we're now in recess on the current executive session, and we'll be back in at least a half hour or so. Colleagues, we're having lunch here. We'll try to fax you lunch.
I'm gonna mute the room.